friends in City Hall saying, you know, we can only do as much as we can do, you know. People run that kind of a mess. And okay, I was just trying to write this out for you in block lettering in case anybody wanted to look at it. My only suggestion is that you add a fifth and final clause to the resolution, which would read, given the serious and complex questions of constitutional property rights law and federal and state law issues raised by the appeal, of which appellant will continue to seek appellate clarification, the department is directed to stay enforcement, including penalties, pending final resolution. I would ask that you do that while we figure out what is the law here.
I would think, Mr. Anthony, that your client is not going to have any fines if he provides evidence to code enforcement that he's harvested. I mean, because, I mean, if he can just take pictures of his pots and send them down to us, I mean, that he won't have any fines.
I understand that, and I really appreciate it. That's very decent, and I think that's a great exercise of your discretion. I do appreciate it. The issue is that he is continuing to cultivate there are baby plants in the greenhouse with some little supplemental lighting and a little warmth so that they'll be ready to plant in the spring as soon as possible. And he continues to assert the grandfathered right, and Honorable Commissioner Wooster, you know, raised the issue of, well, what is continuous? You know, it's uncertain, and so, you know, my advice to him would be to continue that use actively, and therefore not jeopardize the right or the possible right. I mean, I think the notice was issued on the 3rd or something, yeah. So, you know, penalties started on the 14th. So whatever, we're about 3 weeks in. But to get to the Board of Supervisors and then possibly to the Superior Court before we get outside of the county legislative structure, you know, those penalties are going to become even more significant.
I believe that we already stated our ruling on that. The Board of Supervisors will make their ruling on that, and if you get to the Supreme Court, like you state, then I think at that point in time the Supreme Court could rule whether or not those penalties be rolled back. I don't think that would be, it would be going against what we currently have already ruled to put that in position. So I believe even under the ordinance, it states, or the hold harmless for the county that had to be signed under the urgency ordinance, that it states that if you go to court and you lose, then the costs are bared by the appellant, and if he wins, then obviously that's a whole different story. But if he wins, then at that point in time, you could ask for those to be rolled back. But for us to be able to add that to the resolution, in my opinion, would be going against our current ruling.
Okay, fair enough. I would distinguish between costs and penalties. Certainly, you know, losing appellants are liable for all the inspection costs, those kinds of hard costs, regulatory costs. Penalties are a different matter. The department has the discretion. You, as the judges in this matter, have the discretion. I've seen judges in Superior Court issue preliminary injunctions, and when I told, which is an appealable order, and when I indicated that, okay, we're unclear on the law, you're unclear on the law, I respect your ruling, would you give me a stay while we go up on appeal, that those have been granted, and the activity, the right to continue that activity, this is actually a dispensary in Corona, the origin of permissive zoning in our world, was allowed to continue.
I don't think we're unclear. I think we were very clear. The ordinance stated 2 acres. Your client signed the agreement to the 2 acres. So I don't feel as a commissioner that I was unclear on the urgency ordinance and the application that your client and the appellant signed.
You absolutely were not unclear. I think some of the other commissioners may or may not have had questions about this constitutional law issue, property rights, federalism, you know. The thing is, you never know, really, until you get to an appellate court whether a use is grandfathered or not. You just don't know.
Well, then I think then
go ahead.
Then that's where the decision should be made as to whether that resolution should be inserted into there. I'm very uncomfortable with it. The other commissioners can weigh in on that, but I think it would go against the ruling that we currently have on, that we voted for. If the other commissioners were unsure of their position, I can assure you they would not have voted that way, because we don't always agree. This time we did. So I truly believe you need to take that to the courts and let them decide at that point in time if those fees should be rolled back.
And as far as timing goes, I mean, who knows when and if that ever occurs. And I think it provides a disincentive to people following the law.
If if the commission were to decline to adopt your suggested revision and because of the prospect of penalties and so forth, your client were to completely abate his growing operation, would you not be arguing before the courts that his growing ought to be treated as continuous because it was only interrupted by virtue of an administrative order under pain of serious sanctions?
I would certainly, I appreciate your laying out that argument so clearly. I think that that would be one of the options. I might possibly approach county council and, I don't know, maybe we can get a stip. Yeah.
Second question.
Yeah. Yes, sir.
If, the argument that you've laid out could be available to many growers other than your client, and therefore the basis for your request that we adopt this change to the resolution could be available to many people other than your client. And if we were to go along with that request, how would we be able to say that anybody ought to abate? Because they can make the same arguments you did, and then the whole thing just continues with no abatement.
Todd, how would you proceed with those fines at this point? Say he goes to the supervisors, they uphold our decision, and then he goes to the appellate courts, and it takes several months to get there. Would you start the process of liening the properties? Would you be just continuing those fines until the appellate court finishes? What would be the process?
The property would probably be liened after the Board of Supervisors' decision. As far as the accumulation of the fines, we certainly have discretion in that and could always negotiate that.
It's typically not code enforcement's practice to lien for administrative fines. So they lien for costs of abatement and administrative costs. So if this were to go forward, he would, he's already received his notice of violation. Once there's a final administrative order from the board, Sabrina would mail out a notice of final administrative order and demand payment with a calculated sum as of the date of that fine. And eventually, I would probably sue for the money.
Okay. Is the appellant you own the land? You're not a tenant or leasing the land?
Yeah, he owns it. Yeah.
Okay, okay.
Yeah, the lien will be a formidable tool.
Okay.
Is there anyone else that wanted to address the commission on this administrative hearing? No? Okay. I guess I'll close this hearing and public hearing and public comment.
I do have a question maybe of county council.
Okay.
Where the ordinance provides in 17.95.160A that the growing of marijuana other than as permitted constitutes a public nuisance. That's what the ordinance says. What, if any, discretion does this commission have to say that, as a matter of fact, this one doesn't?
Well, I don't think, if the Board of Supervisors is, to the extent that you're finding that there is a violation of the ordinance, I don't think there's any discretion to say otherwise, because if you think that the board clearly evinced its intent in the language, I mean, you'd have to determine whether the plain language of the ordinance reflects the Board of Supervisors' intent, or whether there needs to be further interpretation. And it's ultimately your decision, but if your position, if you feel that this says the Board of Supervisors wants them to be treated like nuisances per se, and that's what the commission believes, I would say that your first and foremost duty is to apply the board's intent in your interpretation of the statute, if interpretation is even necessary, because the plain language might suffice.
Okay.
Don't have anything to say at this moment.
Well, I'm prepared to uphold the abatement order. I don't think that this is de minimis.
I agree.
All right, I think is it the same, ready for the recommendation?
Yeah, and this, yes, the uphold the findings of the code enforcement officer.
Okay. There's a motion. You moved. Second?
Second.
All in favor? Say aye.
Aye.
Aye. Motion carries 5-0. Next is on our administrative hearing is 2016-004 Dickinson Appeal of Code Compliance Citation.
Dickinson elected not to attend, and he did not ask for continuance. But here's his appeal letter. I spoke to his lawyer for quite a while yesterday, and after we discussed what the appeal actually involves and the issues that would be reviewed, he said, it's not worth the 5-hour drive.
Is there anyone, also the appellant is in here, is there anyone else that wanted to speak to the commission regarding this? No? Okay. Discussion?
Well, the appeal seems to be based on the thought that at the time this appeal letter was written, there was an appeal before the County Planning Commission, but that's come and gone.
Correct. Yeah, he went all the way to the board and lost.
So I don't see any basis in the appeal letter to overturn the recommendation.
I don't either. There's nothing in the letter.
I don't either. So is there a motion to, I already did. Motion to deny the,
So moved.
the appellant's request?
Second.
Seconded.
All right, we'll give it to Kelly. Moved and second, all in favor, say aye.
Aye.
Motion carries 5-0. The next item was removed. And the last one, 2016-005 Stapleton Appeal of Code of Compliance Citation.
Once again, I failed to put this in the report. And Stapleton missed his deadline to appeal his planning commission, the planning department's finding, but he did so because notice was sent to his physical address and not his mailing address, and Peter has elected to extend the deadline for his appeal. So there's really no reason to hear this one today until after his planning commission appeal has been heard. So we ask that we continue it to a date.
A gift.
after the planning commission appeal has been heard of this case. At this point in time, we don't have an appeal date, so we'll keep it up there.
Okay.
And we'll try to schedule it with the, have it heard the same day as the appeal of the planning department action.
Do we need a motion? Is he
I
going to waive
would like
time?
to,
Hold on.
Yes, yes.
The villain's waive time?
I spoke with the appellant,
Right.
he was here earlier today. and agreed to
Okay.
Okay.
I would like to make a motion to continue this until the appeal hearing.
Is there a second? Second. Moved in second. All in favor, say aye. Aye. Motion carries. Done. So with that, we are adjourning the administrative hearing board, and we are officially adjourned, and thank you all very much.